Hello, I'm television and radio producer, presenter Rob McKnight. With over 30 years' experience, this is Media McKnight. Well, things might seem quiet on the Carl and Jackie O front this week, but there is lots to go through in terms of the new documents released by the federal court. These documents contain the initial claims, the defence, and the applicants' replies. Now, there's some fascinating insights, but before I get into that, last night on McKnight Tonight, I spoke with intern Pete. Now, you might have heard he's moving over to Gold FM to join the Christian O'Connell show. But when I spoke to him, he revealed his mental health has suffered as a result of the Carl and Jackie O drama. Had you seen that the relationship had been deteriorating over time? Are you surprised by what she's putting in these court documents from your perspective?
From my perspective, genuinely, I've seen it, I've watched it, and I've read bits and pieces. I've had to the last couple of months last month or so from a mental perspective, because once it started going down course and stuff, it's a whole nother level, right? But I found it mentally hard to believe what was real and what wasn't until the court stuff. And I found it, everything that's coming in from every angle is just, it's actually a little bit much for me mentally, to be fair. And that's not me trying to not answer the question here, by the way. I just find it all confusing. All I know is when this ends, however that does end in the version, that's the part that I want to pay attention to the most, because that's the part where everything's on the table and that's where it's landed, because everything else at the moment for me is just a little bit fog.
Well, it's like mum and dad splitting up in a way, isn't it?
Yeah, that's right. And that's exactly what it is. And, you know, when you work on that show for this amount of time, that dopamine high is so high, it got cut. And for me now, I get this amazing opportunity to go and get that dopamine hit every morning with Christian O'Connell.
Yeah, intern Pete starts on the Christian O'Connell show on Monday, May 25 on Gold FM. You can see that full interview on my YouTube page at youtube.com/@McKnightTonight. Meanwhile, let's turn our attention back to the new documents released by the federal court. In this episode of Media McKnight, we're going to go a little deeper by showing the claims and counterclaims. To help me do that, who better than employment lawyer Michael Byrnes from Swaab. Michael, welcome back to Media McKnight.
Good evening, Rob. Good to be with you.
Mate, it's interesting to see intern Pete there, isn't it? Because we have been so focused on Kyle, Jackie O and ARN, but there's a whole team of staff who haven't known what their futures hold. Luckily, ARN seem to be doing the right thing by them.
Yes, it seems so. It must be difficult for them. You're right. For us, it's theoretical. We can watch it one step removed, but we do forget there's a large group of people who worked with Kyle and Jackie O whose working lives have been affected by this. So it was very interesting to see that interview with intern Pete, and good that he's landed on his feet with Christian O'Connell. I think a good move for the Christian O'Connell show as well, to be able to take some of that Kyle and Jackie O audience over to his program. So sounds to me, I'm not here to comment on radio as such. I should stick to the law, but from a radio strategy perspective, that seems pretty smart to me.
Michael, we will get your comments on just about anything, so don't you?
I should
don't
stick
you
to my lane,
yourself.
probably, Rob. But anyway,
hey, let's get into the documents now.
Yeah.
There isn't as much back and forth in Jackie's case as there is Kyle's, so tonight we will mainly focus on the documents with Kyle. But can you give me an overview of any new information we have regarding Jackie's case?
Just a few things that fall out of it, Rob. So one is that she says that no ARN staff member attempted or did successfully intervene in relation to Kyle's conduct on 20 February. So that had been part of ARN's defence. She says that didn't happen, that no one attempted to or successfully intervened in relation to Kyle's conduct on 20 February. There's that.
We will go into that element a little later, but that really does seem to strengthen Kyle's case, doesn't it?
To some extent, perhaps, in that people just thought it was normal run-of-the-mill behaviour for the show, part of the dynamic, the cut and thrust, the dynamic of the show. So you're right, it might assist Kyle because it's not so out of the ordinary that it warranted intervention by anybody. And indeed, as will be noted in relation to Kyle's reply, the censors didn't do anything either. So that's one aspect of Jackie's reply. Another is that even though ARN says that Henderson Media is responsible for Jackie's safety, in other words, Jackie's responsible for her own safety, the reply says, and I think quite rightly, that obligations under the Work Health and Safety Act can't simply be delegated in that way, that whilst Henderson Media might have had some work health and safety obligations in relation to Jackie, ARN also retained certain obligations to create a safe or maintain a safe workplace for Jackie. So that's one aspect of Jackie's reply. Another is that if ARN did investigate any of the complaints she made in August or September, particularly in September, she was not involved in any such steps nor knew about them. So that's another big piece of information out of Jackie's reply.
It is fascinating. So we'll obviously keep abreast of what's happening in her case, but there is so much more with Kyle's because there's a lot more documentation back and forth. And what I want to look at tonight, we've gone through. So if you want to know where we are up until this point, there's other editions of Media McKnight and McKnight Tonight where Michael gives his expert analysis of the documents we have. But tonight, I want to look at the parts where the parties disagree. So the idea here, Michael, is anything that's sort of agreed fact that we've talked about, we're moving on from that. So
Sure.
basically, I'm going to start with paragraph 16 of Kyle's claim. Now, he states, the impugned conduct was conduct of a robust character of a kind that CBC contractually acknowledged that Mr. Sandilands was likely to engage in the performance of radio presenter services and which CBC indicated to Quasar that it desired. It was not conduct that constituted a radical departure from the relationship established by the Broadcast Services Agreement that was inconsistent with the continuance of that relationship or otherwise conduct capable of constituting serious misconduct for the purposes of the BSA. But the defence says, in part, the conduct engaged in by Mr. Sandilands was not conduct that CBC desired Quasar or Mr. Sandilands to engage in, or conduct that was required to be performed under the Quasar BSA, and to the extent that the particulars to the paragraph make an implicit allegation about the nature of the relationship between CBC and Quasar, the particulars are embarrassing in that there no material facts are pleaded to establish the nature of that relationship. So both sides seem to be arguing ARN had different expectations of Kyle here.
Well, Kyle's argument or case is summed up with this notion of you buy Kyle, you get Kyle. So what Kyle's side are saying is that Kyle on the 20th of February was acting consistent with the robust character that was acknowledged and desired by ARN. And therefore it can't be, is not serious misconduct. So that's Kyle's position. ARN are saying, no, this is not what we wanted. This is not what we desired. It is not what we've contracted for. It's outside of it, and it's serious misconduct. So, pardon me, in a way, that sums up the differences between the parties. Kyle saying, you buy Kyle, you get Kyle. He acted, he wasn't a saint. He wasn't choir boy, but he was acting in a manner which was consistent with what ARN had contracted for. ARN saying, no, the conduct on 20 February was not what we contracted for. It was not desired. It was not part of this so-called robust character that we wanted. It was well outside that. In some ways, those two passages sum up the fundamental differences between Kyle's position and ARN's position.
One thing that stood out to me was this, the particulars are embarrassing. That's from ARN. And I do note somewhere in Kyle's, one of his documents, they call the ARN side's pleadings embarrassing. Is that common?
I'm going to disappoint you here, Rob. I'm going to disappoint you because it's not embarrassing in the social sense that you ought to be embarrassed about what you're writing down here. It's just another way of saying that they are vague, that they are not capable of being responded to because they are just too vague. They don't make good the proposition that they are supporting. That's all it means.
So it's pretty
really
common for lawyers to do this to each other.
It's a common term that your pleadings or your particulars are embarrassing, and because they're just too vague. They
Gotcha.
don't set out what it is with sufficient specificity or particularity to support the claim that is being made. So that's all it is. It's not meant to be a term, an emotive pejorative term, like a sledge to the other lawyers. It's not that. You might read it in that way. It's more fun to read it in that way, but it's just a term of art used in pleadings when a pleading is vague.
Okay. Now we move on to the infamous broadcast of February 20. It is at the heart of this case, with ARN claiming the 20 February conduct caused Ms. Henderson serious hurt and offence and caused her to become visibly and audibly upset. Now, we've had the statement of claim, we've seen the defence, and now we have Kyle's reply to that defence. In reply to that paragraph, the Sandilands applicants admit that the 20 February 2026 conduct caused Ms. Henderson to become visibly and audibly upset, say that the state of affairs was observable by the censor, say that the censor did not dump the material constituted by the 20 February 2026 conduct. So you sort of hinted at this before. Is this an attempt to blame the censor for the argument being broadcast? Therefore, it couldn't be a breach because they let it go to air.
That's exactly it. Kyle's argument is centred around, or one of the key aspects of Kyle's claim is that there were these censors in place, and the censors, if they had formed the view that it was misconduct, they should not have allowed it to go to air. They should have stopped it, and they didn't. They failed to do that. And Kyle's position on this is that it goes beyond mere regulatory breaches, because when we think of censors, we think of broadcasting regulatory breaches, but goes to misconduct generally under the Broadcast Services Agreement. So what Kyle's camp are saying is it's not as if this was not known to the censors. Jackie was audibly upset, visibly upset. That was something observed by the censors. If Kyle had engaged in serious misconduct, the censors should have stopped that, but they didn't. And so it's almost like ARN condoning it in a way by allowing it to go to air. And Kyle's camp would say, well, the reason they didn't stop it and the reason it went to air was because, having regard to the history of the show and previous arguments and previous incidents, particularly the way that ARN monetised and promoted those incidents, it wasn't out of the ordinary. It didn't really elicit a reaction from the censors because it was, part of the program, of the usual program. So that's part of Kyle's argument, that there were these censors in place, and if the censors allow it to go to air, it can't be serious misconduct. If the censors don't act on it, it can't be serious misconduct. That's the effect of Kyle's argument in that regard. They're putting a lot of weight on these censors. And what they say is that the contract provides a basis for them putting the weight on those censors. It's a creature of the contract. Because, Rob, ordinarily when you think of censors, they're not there to stop misconduct as such. They're there to stop broadcasting regulation breaches. But here, they had a special role under the contract.
Well, they've got two censors. No other radio show has any censors. In television or radio, the only
pretty unusual.
Big Brother would have a censor when contestants were coming out, and because of what's going on in there. I really wish I'd clipped this up, but in the interview with intern Pete, he talked about this argument. I asked him about it, and he said,
"Oh, right,
they've had so many arguments," and he said the only thing that seemed different about this one was no one got up and walked out. Usually someone has the hissy fit and walks out.
Yes.
But no one did on this occasion. And he said that was the difference, because usually Kyle or Jackie would storm out.
Yeah.
So
and it's a circuit breaker, presumably, between the two of them.
Yeah. And
presumably,
interestingly, So it was common conduct.
Yes. Well, that's Kyle's argument. And indeed, he cites various examples in his reply. And not only cites examples of arguments that they had had, and by the way, in his reply, he basically says Jackie gave as good as she got, pretty much. But he not only cites these examples of arguments, but also that they'd been promoted and included on podcasts and all of that. So that this is a key plank of his argument. He's not claiming he's a saint or that he's perfect, but his case is 20 February was no different to a range of other exchanges that had occurred between him and Jackie.
It's fascinating. Well, there's then a lot of the material we've previously gone over about Jackie's complaints against Kyle. CBC details them, but Kyle's team make this point, and they say that the Sandilands applicants were not told that the communications referred to in paragraph 16J and 16R had occurred or were alleged to have occurred until after CBC purported to terminate the Sandilands BSA. And Jackie backs that in her reply, saying to the extent that the respondents took any steps to investigate or address the complaint made by Ms. Henderson on 11 September 2025, as pleaded in paragraph 21, between 11 September 2025 and 8 December 2025, no such steps were notified to Ms. Henderson, nor was she involved in any such investigation. We covered this a little moment ago, but this seems a pretty important fact to me. We talked about it, that Kyle was never told there was a problem with Jackie.
Yes.
He never had a chance to fix that.
This confirms what we strongly suspected, that Kyle perhaps was genuinely blindsided by all of this because he wasn't told about Jackie's complaints in August or concerns in August and September, never told about it. And that's what his reply says. He wasn't told about it, nor were his companies informed. So presumably, maybe it's slightly presumptuous on my part, but it presumably means Bruno wasn't told either to relay it to Kyle. So Kyle didn't know, his companies weren't informed until after the termination of his services agreement.
Well, we've
And
seen no
indeed-
documentation that suggests that Kyle or Bruno were informed, right?
No, that's right. And indeed, you would think, Rob, that if they were, ARN would put that in their defence. They would say, we spoke to Mr. Sandilands on this date, we spoke to Bruno on this date, we told them the conduct's unacceptable, they indicated they understood that, they said it won't happen again, and then lo and behold, it did happen again. None of that is in ARN's defence. So what is written in the reply rings true, and it's a point made for emphasis that they did not know about any of these complaints made by Jackie. And similarly, of course, and as you say, it marries up, Jackie was not notified of an investigation, or if there was an investigation, she wasn't involved in it. So query whether ARN actually did escalate these matters and undertake some sort of investigation or examination of them. It seems they didn't. It seems they didn't.
There's a complicating factor that in one of the affidavits, I think Jackie's, or maybe ARN's statement, I can't remember, where it's pointed out that there was a follow-up and Jackie said,
Yes.
oh, it's okay, don't worry about it.
That's a really interesting aspect factually of this case. So it'll be interesting to see when the affidavits arrive as to how this is dealt with. So Jackie's case seems to be predicated on this idea that she made a complaint on 11 September, I think it was, in relation to a broadcast on the 10th of September, but then nothing happened. Whereas ARN, they refer to some other incidents or exchanges, I should say, not incidents.
Lauren Joyce
writing to Gemma O'Neill, who's Jackie's manager, to say, we take safety, this is Lauren on behalf of ARN, we take safety very seriously, and we want to look into the matter. Can you provide us further information or details about it? And then Gemma writes back to Lauren on the 16th, I think it is, of September, and says something to the effect, you've got the information you need. Jackie has provided the particulars or the specifics to Derek Bargwanna. You've got what you need. And then on 8 December, Jackie says, no need to look into it any further. Now, there's no reference, as far as I can see, and I could be mistaken, to this 15 September and 16 September exchange, these exchanges between Lauren Joyce and Gemma O'Neill. They don't seem to be in Jackie's material.
No.
Jackie's point, though, in the reply is, well, we don't know what ARN did because we weren't notified, or Jackie wasn't notified of any investigation. And if there was an investigation or an inquiry of some kind into this, she wasn't involved. So it'd be interesting to see how that evidence plays out in court.
Interesting. Hard to do an investigation. Now, of course, companies can do investigations whether the worker wants it or not. But when you've got the Star saying, no, it's okay, and basically saying, I spoke to DB, everything's fine, or it is what it is. I can't remember the exact words, but she basically gave them a free pass.
Well, she does on 8 December, Rob, even on ARN's own case. It's not until 8 December, I think, that conversation occurs.
Right.
Where Jackie says, leave it. No need to take it any further. So there's this period from 16 September when Gemma says, you've got what you need, to, and by the way, I interpret that as Gemma, and of course, we'll need to see how the evidence plays out on this, but I interpret that as Gemma O'Neill saying, proceed with it, you've got what you need, so go ahead with it, not Gemma saying, don't worry about it on 16 September. So you've got Gemma saying that, and then on 8 December, Jackie, it is said in ARN's defence, in their defence document, that Jackie said, well, don't worry about it now, just leave it.
Which hasn't been rejected in anything that I've seen. But
no,
it's interesting.
I agree. Yeah, I agree, Robert. That hasn't been rejected as far as I can tell.
It's interesting how you interpret Gemma's response. I interpret it like, look, you've got the information. I'm sort of done with it. That's how I interpret it.
Well, maybe ARN interpret it the same way, and it may well be what Gemma O'Neill intended, but I read it as, you're asking me for a whole lot of particulars and information. You've got what you need. Jackie spoke to Derek Bargwanna, raised the issue, so go ahead with it and deal with it. That's how I interpreted it, but I could be wrong and really probably shouldn't be second guessing in a way what Gemma wrote or said at that time. But that's the way I interpreted that 16 September exchange. Be very interesting to see when the evidence emerges, the complexion that is put on that conversation by the parties involved.
Now, this next part was telegraphed by Kyle's lawyer in court because they support CBC's assertion that Jackie repudiated her contract. Let me take you through it, starting at 16S for the defence. The complaint letter unequivocally conveyed the objective, meaning that Ms. Henderson would not present a radio program with Mr. Sandilands again. 1. The complaint letter stated that our client cannot continue to work with Mr. Sandilands. 2. The complaint letter stated that direct conduct with Mr. Sandilands is now untenable. 3. The intention objectively conveyed by the complaint letter that Ms. Henderson would not present a radio program with Mr. Sandilands again was unequivocal, not limited in time, and not conditional upon any future contingency, and in particular, it was not subject to CBC agreeing to an alternative co-host or to CBC first addressing any putative health and safety concerns to Ms. Henderson's satisfaction. Now, in the reply, Kyle admits that by the complaint letter, Henderson Media and Ms. Henderson, collectively Henderson parties, repudiated the Henderson's BDA. Now, there's a bit more to come on this, but I remember ARN's lawyer being a bit surprised in court when Kyle's lawyer said they would support ARN's notion that Jackie repudiated her contract. What's the play here, Michael?
I don't think there's much to it, Rob. Sorry to disappoint you.
Oh, you think I'm blowing it out? You think I remember, though, ARN's lawyer went, well, we didn't expect that. He said something like, we didn't expect that.
Sure. No, I recall something like that. I mean, the key part of those two parts you showed, extracts you showed, the key part was the first one, because that goes to what ARN are really going to be focusing on with Jackie, that 26 February letter, which they're going to say is her repudiating the contract. And that's what their case is very much going to focus on. But to your question, an excellent question about Kyle, I can understand why people might think, having heard that, oh my goodness, Kyle's just throwing Jackie under the bus.
That's how it felt.
Yeah, no, that's
to a novice like me who doesn't
I know, I can
know the law.
understand that. I can fully understand why that would be an eyebrow-raising moment. Gasps in the courtroom type moment. And it's unfortunate that maybe if they get you as the YouTube producer, that drama in the courtroom could be felt by the viewers, remote viewers. But I think you'll find, Rob, that concession was simply made so that is not an issue that needs to be determined in Kyle's proceedings in support of an argument that Kyle's case can be heard separately. Because if the matter needs to be determined in both Kyle's and Jackie's proceedings, that militates against them being heard separately. The judge says, well, I can't make two separate findings on the same issue. So what Kyle's lawyers did, this is my understanding, what Kyle's lawyers did was to neutralise the issue, to say, well, Your Honour, you don't need to make that finding in our case. For the purpose of our hearing, for limited purposes, we will admit that ARN validly terminated Jackie's agreement. And so you don't need to determine that in our case. And for that reason, we can have the matters heard separately. And you might recall the reason Kyle's lawyers wanted and still want the matters heard separately, although that seems like now a forlorn hope, is so they can...
there hasn't been a ruling on that yet, has there? The magistrate...
Not a final
magistrate or judges.
Oh, no, Rob. No, you better pack your toothbrush if you're going to call a federal court judge a magistrate. It's a justice. Yes, a judge of the federal court. Even in fact, in New South Wales, our magistrates are now called judges, actually. So there's a bit of title, with all due respect, a bit of title inflation. I need to be careful. I'm an officer of these courts, so I need to be very respectful. But no, it's not your worship, it's your honour, and they are justices of the federal court. Justice Stewart's an incredibly...
So if I'm in court, I shouldn't say Your Majesty.
No, not Your Majesty, not your worship. But we've all made mistakes. If you're going to make a mistake, it's better to give them a higher status that they deserve rather than a lower status. It's the lower status that's the problem.
But we haven't had a verdict from the justice regarding whether they're separate or together.
That's right. The judge hasn't made a final determination on that. But it's looking increasingly like they will be heard together, either concurrently or consecutively. The judge, I think, is very much leaning towards that. And in some ways, the expedition argument, I think, now has fallen away, and the Sandilands camp are resigned to a hearing in October. You might recall...
Which is still pretty fast, right? You wouldn't usually get a case like this through that quickly.
No, I'm surprised it's this year. I'm sure you have some pedants, Rob, who watch your wonderful program, who probably go back to previous episodes, take notes of things that I've said previously that perhaps haven't quite come to pass, and perhaps send them in. I don't want to invite that, but there might be people that do that. One of the observations I was making earlier on was I think it's highly unlikely it will be this year. That was before it was known that Kyle was going to run this specific performance argument. The specific performance argument gave him the basis to seek to expedite it. You might recall in court last time, there was a dramatic moment where the barrister for Kyle asked to be excused from the bar table so he could take instructions. And that was about the dates for hearing. and whether they could live with October. I don't think they were happy with October, but sometimes it's a question of what can you live with? Might not be perfect, but you can live with October as opposed to, say, June, which was the original date set down for Kyle's hearing. It was going to be, I think, 22 to 25, 26 inclusive. So that's, yes, that's the reason I think you'll find they made that concession. It's for a limited purpose, and it's not a matter of Kyle saying, or Kyle's camp saying, Jackie's going to lose and we're throwing her under the bus. Ultimately, Kyle's position on the merit of Jackie's claim is neither here nor there.
Yeah.
It just really doesn't matter.
Yeah. And I want to defend you for a moment. You give us your expert advice based on the information we have at hand. Things change in a case like this. There's new arguments, there's new evidence, and this is why we're doing tonight's video. We're going back to this case because there have been new documents, and it's a case we are following through. So don't ever apologise for having a change in opinion when there's been new evidence.
Oh no, that's exactly right. That there are changes of circumstances and changes in the information, which obviously impact on the analysis. And this is part of what's been so interesting about this, Rob, in that early on we're sort of in the dark as to a lot of things, and so left to guess, to speculate, shadow boxing in a way. Whereas now, as more and more documents are filed, as more is known, the commentary can become more specific and more informed about the way in which these cases are going to be run and what we're going to see in court later in the year.
And by the way, for anyone watching or listening, you can go and look at all these documents. The federal court has made this a case of public interest. And if you go to the Federal Court of Australia and go to the public interest cases, you will see Sandilands and Henderson and ARN. And you can go through and you can pull up every document. So we've done that. We're doing the hard work for you. Let's continue with what Kyle has to say in terms of Jackie's contract, because he says, in breach of the said term, CBC did not use its best endeavours or any endeavours to ensure that Ms. Henderson performed her services at all relevant times after it received the complaint letter. Instead, CBC elected to terminate the Henderson BSA and not rescind that termination in circumstances where it could have instead elected to affirm that contract or rescind the termination and endeavoured to ensure that Ms. Henderson performed her services at all relevant times. What point are they trying to make here, Michael?
So it's a term of Kyle's services agreement that ARN use their best endeavours to procure the availability of Jackie and that she performs her services. So ARN are under this obligation to use their best endeavours to procure Jackie performs her services. And what Kyle's camp are saying, well, ARN failed to do that, because what ARN did was to, when Jackie repudiated her employment contract, her services agreement rather, they terminated her services agreement. They terminated her services agreement. So that's inconsistent, inherently inconsistent with the notion of procuring her performing services if you're terminating her services agreement. And the argument centres around this notion that even if Jackie had repudiated her services agreement, that leaves what's called the innocent party, which would be ARN, with an election, a choice that they can make. Now, even if Jackie did repudiate her contract by reason of the 26 February letter or some other conduct, even if she did, ARN weren't under an obligation to terminate her agreement. They could have accepted the repudiation and kept the contract on foot and required her to perform services. So, for instance, instead of terminating her agreement as they did after receipt of that 26 February letter, they could have said, Jackie, no, it's not open to you to demand, as she did in the letter, another day part. It's not open to you to do that. Sorry, we are requiring you to perform your services by turning up and doing the breakfast show with Kyle Sandilands. So that's what Kyle's camp are saying. Kyle's case is this part of Kyle's case, that instead of electing to keep the contract on foot, even though Jackie had had repudiated it, they took the chance and terminated it. And by terminating her services agreement, they say, how is that consistent with the obligation on ARN to use best endeavours to procure that Jackie perform the services under her services agreement? So that's the argument. I don't think it is a particularly strong argument. For this reason, that I don't know that best endeavours ultimately extends to an obligation to elect to keep a contract on foot that has been repudiated. So ARN, I think, will say, well, the contract was repudiated, we're entitled to terminate, and an obligation of best endeavours to procure her services doesn't extend to us having to keep a repudiated contract on foot. I think that's what they will say. But that's the argument.
Is it a case when you've got cases like this, you just throw a lot of shit at the wall and you're trying to make arguments? Well, I mean, there's obviously key elements to a case.
Yes,
To me, there's like 3 key elements to this case. Carl and Jackie O had a blow up. ARN, Jackie O complained. ARN essentially terminated her contract. They gave Carl 14 days notice and then terminated his contract. Was that fair? Now, stuff like...
No, the last bit's not quite right, Rob. That's quite a gloss on the...
I am doing a gloss, but my point is that the idea of whether ARN should have done their best endeavours to keep Jackie O, I mean, Carl's case doesn't hang on that. That's my point.
Rob, you're absolutely right. I couldn't agree with you more. I think it's one of the more marginal arguments in the case. That the main plank or platform element of Kyle's case is this was not serious misconduct.
Yes.
Because of all of those circumstances we've spoken about. It's not serious misconduct, doesn't rise to that level under the terms of the broadcast services agreement, Kyle's agreement. Because you get a lot of people, Rob, they say, you shouldn't condone this behaviour. Kyle acted terribly. He was horrible to Jackie. He was rude to her. Surely that's serious misconduct.
But that's a moral position, not a legal position.
That's a moral position. Exactly. The court is not going to be taking a moral position. They're going to be looking at the conduct, considering it objectively, and considering it in the context of the particular terms of this very unusual agreement. It is a very unusual agreement. Kyle's services agreement, broadcast services agreement. And so it needs to be considered in the context of or against the backdrop of this very unusual agreement with unorthodox terms that give Kyle a great deal of latitude.
In the particulars, there's a bit of back and forth that I reckon's worth going through to get your take. At paragraph 16Y, ARN lays out why it had little control over Kyle, saying, A, Quasar was an independent contractor. Quasar is the business that basically deals with ARN and hires Kyle to do the job. Mr. Sandilands had no legal relationship with CBC. C, the Quasar BSA provided that, subject to the other terms of the Quasar BSA, Quasar was solely responsible for controlling the manner in which it provides the program services. Now, the defence says the dynamic nature of live radio, this continues on, such that once the program commences, there is limited capacity for CBC to control what the presenters do, and Mr. Sandilands had been co-hosting the Carl and Jackie O show with Ms. Henderson for over 20 years. CBC was reliant on Quasar through Mr. Sandilands to fulfill Quasar's obligations under the Quasar Broadcast Services Agreement, including the management of Mr. Sandilands' relationship with Ms. Henderson. This then takes us to the heart of ARN's defence for serious misconduct, because in paragraph 16Z, where they say, A, the centrality of Ms. Henderson's participation to the program, B, Mr. Sandilands' destruction of his relationship with Ms. Henderson in circumstances where the management of that relationship was fundamental to the commercial object of the Quasar BSA, C, the seriousness of the 20 February conduct, including because it was workplace bullying and harassment, which by itself constituted serious misconduct for the purposes of Clause 17.1A of the Quasar BSA. The fact that, sorry, we've got one more page, Amanda. The fact that the 20 February conduct was not isolated or accidental, but part of a persistent course of workplace bullying and harassment of Miss Henderson, of which she had complained. And E, the fact that Mr. Sandilands' bullying and harassment was so severe that Miss Henderson refused to ever work with Mr. Sandilands again. The 20 February conduct was serious misconduct for the purposes of Clause 17.1A. Now, you know, there's a lot there. I'll read out Kyle's defence in a moment, but we know ARN stated to Kyle and the market the reason he was sacked was because of that February 20 broadcast.
Yes.
I keep wondering how they plan to broaden it out and whether that can be submitted to include alleged bad behaviour from the past.
Well, I think they're going to have some difficulty with that, or a problem with that, which is it seems like it was never raised with Kyle.
That's
So
right.
to the extent they're relying on this course of conduct, and you're right, the initial statement to the market referred to 20 February. It seems that the letter seeking him to remedy the breach, the alleged serious misconduct letter that he was issued prior to termination, that referred to 20 February, and now they've broadened it out from 20 February to a course of conduct. The problem they're going to have, I suspect, is that it wasn't raised with Kyle. So how do you reconcile it being so serious that it constitutes a course of conduct that was serious misconduct with not actually rebuking Kyle about it or warning him about it or counselling him about it? So I think that's an inherent problem they have in relation to the other incidents. I don't think it means they can't raise them. I think it goes, though, to the weight that those previous incidents will be given by the court. I think it is a matter that might weaken the impact of those previous matters.
Is it possible the judge would say, you fired him for the Feb 20 incident, all this other stuff has no relevance?
It's possible, Rob, that view might be taken. It depends upon the way in which it's formulated, but it's possible that the judge might say, well, you relied upon the 20 February incident at the time of termination. It's now not open to you to broaden it out and to rely on other incidents in circumstances where you're aware of them. See, sometimes you can rely, and I'm talking here about employment, and appreciate this is services agreements, and similar but not identical principles apply. But in employment, if you become aware, if you terminate someone for a particular incident on a particular date, but then you find out later, and they then dispute that termination, but then you find out later that they're engaged in other matters of which the employer was not aware, the employer might be able to rely upon those matters of which they weren't aware at the time of termination to strap up or support the termination for serious misconduct. But here there can be no argument about ARN not being aware of these matters. They were absolutely aware of them because they were broadcast or they were complained about. So I think that does weaken ARN's reliance on these other matters. But I think what ARN are trying to do here is to argue that there's been a persistent conduct, a pattern of conduct. The 20 February wasn't a one-off, wasn't an anomaly, but similar conduct had occurred before. And that's to try and help them argue that it is serious misconduct within the terms or within the meaning of the relevant clauses of Kyle's services agreement, which I think refer to persistent conduct or persistent breaches. The word persistent is used, so it's likely used to try and demonstrate that.
Does ARN's case fall apart if they can't use that evidence or can't rely on it so much?
I wouldn't say it falls apart, it just weakens it. I wouldn't say it falls apart because you've still got the 20 February exchange.
Sure.
And so ARN will say the 20 February exchange, and they are saying the 20 February exchange constitutes serious misconduct. And they're doing that in a few ways. One, objectively, it was bullying and harassing conduct. It was unacceptable conduct on the part of Kyle. And you might recall I said that transcript and the audio of the 20 February incident or episode will be looked at more than the Zapruder film when it comes to court, and it will be. It'll be very, 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 very carefully examined. You know, the language will be parsed, the tone, all of that. So you've got that objective analysis. Then you've got, and this is a product of Kyle's services agreement, you've got the conduct objectively considered. Then you've got its impact on Jackie. Its impact on Jackie. And so ARN is saying it's not only misconduct because of what Kyle did objectively and carrying on in that way, it's also misconduct because by reason of that conduct, Jackie was then unavailable or refused to perform her services. And that is central to Kyle's services agreement to work with Jackie. And so for that reason, because it had that impact on Jackie, that is also serious misconduct. That's another basis upon which this is serious misconduct. So it's not only the conduct as objectively considered, it's the impact that it had on Jackie by meaning that she refused or was unavailable to then present with Kyle, which is why I think they would say, well, we got her letter on 26 February. We then terminated her agreement after her repudiation. And at that point, we then, given that Jackie was no longer available, refusing to work with Kyle, that provided a basis upon which to then say to Kyle, this is serious misconduct.
Mm. All right, well, let's take a look at Kyle's reply to what ARN is saying. He says the conduct complained of by CBC was not serious misconduct for the purposes of the Sandilands BSA. CBC is e-stopped from asserting that it is in circumstances where it is encouraged or induced the Sandilands applicants to engage in conduct of that kind. What does that mean, Michael?
So it's this legal concept called estoppel. So someone is stopped from doing something. So they want
ARN to stop making this claim that it was serious misconduct.
In a way, what they're saying is that ARN shouldn't be allowed to make this argument. So, and the reason for that is this, that ARN encouraged or induced a belief or an assumption in Kyle that this sort of conduct was permissible. In fact, that this sort of conduct was desired. It was a belief or an assumption that Kyle had, and he had it. He was encouraged or induced in that assumption by the conduct of ARN. Specifically, ARN putting these fights in various podcasts, repeating the broadcasts of these fights, even promoting some of the podcasts by referring to these fights. So Kyle had this assumption, and it's now not open to ARN, contrary to this conduct that they've engaged in by encouraging this belief or inducing this belief that Kyle had that it was acceptable, it's now not open to ARN to resolve from that and terminate, citing serious misconduct.
And does it hurt ARN that they didn't pull him off the air after if the 20th of Feb broadcast was serious misconduct? He remained on air for almost a week.
Yeah, I agree. I think that is damaging to ARN's position. It seems to me difficult to reconcile the notion that the conduct was so objectively serious that it's inconsistent or incompatible with the continuation of the agreement with keeping him on air. I think ARN's position on that is going to be, we did not know, we certainly obviously knew about the gravity of the conduct itself because it was broadcast. So you heard what Kyle said and did on that day. That can't be denied. But the impact of it, which is a central plank of ARN's case, that is the impact being Jackie refused to continue to work with Kyle, that wasn't known until sometime afterwards. Mind you, though, if you look at the chronology in this, the letter from Jackie, I think, comes on the 26th of February, which I think you'll find is a Thursday.
Mm.
And it's only then on the following Tuesday that Kyle is taken off the air. As I recall the chronology, Kyle was actually off sick, coincidentally, on the Thursday
Yep.
for the breakfast show, but he was back on air on the Friday, and then back on air on the Monday, and back on air on the Tuesday. The announcement, the ASX announcement from ARN, was made at around 5:30, as I recall, on the Tuesday. I think it was the 3rd of March.
Yeah, that's a
So they
problem.
kept Kyle on the air, but even after Jackie had submitted the letter saying that she could no longer or could not continue to work with Mr. Kyle Sandilands, and that direct contact between the two of them was untenable. So they did keep him on air even after that. I think they'll have to explain that in some way.
You know, you bring us to an interesting part, because when ARN gave Kyle 14 days to remedy the alleged breach of his contract, you and we all wondered how he could do that when he wasn't allowed to talk to staff or enter the building.
Yeah.
So this is an interesting point with what ARN says about this, because they say the word reasonable in the phrase reasonable opportunity in clause 17.1a of the Quasar BSA refers to the period of time within which the serious misconduct may be remedied, rather than the quality of the opportunity, as is made clear by the words used: reasonable opportunity by notice in writing, not exceeding in 14 days, and by the fact that the clause provides that no opportunity to remedy is required to be given in circumstances where the serious misconduct is not capable of being remedied.
Yeah.
Now, I've got to assume this is going to be a bone of conjecture between the parties.
Oh, it is, absolutely. So ARN are going to say, look, we didn't even need to provide an opportunity to remedy. We did. And even if it's accepted that we did need to provide an opportunity to remedy, it doesn't need to be a good opportunity. The quality of the opportunity doesn't matter. It's to be measured in days.
You were laughing when I was reading that.
It was measured in days. So that's ARN's position. Kyle's position will be, I was denied an opportunity to remedy this. If I'd been given that opportunity, I may well have been able to do so, to remedy, to fix the relationship with Jackie Henderson.
Do you think that's a stretch? Because you did laugh.
It is going to be a point of contention. It is going to be a point of contention in the case.
All right. ARN uses Jackie's complaints about alleged bullying by Kyle as cause for his termination. How does that reconcile in Jackie's case that they did nothing about the alleged bullying? This is something we've talked about a bit, but I just can't get it in my head.
It is on the face of it difficult to reconcile. It's part of this tightrope or high wire act that ARN is running. Mind you, bear in mind, Kyle's and Jackie's cases are run on different bases. So I think it's a flaw in ARN's position that on the one hand, they're saying Kyle engaged in this outrageous improper behaviour or misconduct, bullying and harassment of Jackie, and that there was a course of conduct in which he engaged, yet they didn't raise it with him. Yet on the other hand, they don't have regard to that, it seems, in looking at or examining the letter from Jackie on 26 February. And what's more, according to Jackie, if they did investigate the matter, and indeed they haven't pleaded that they did, if they did investigate the matter, then Jackie didn't know about it, Jackie wasn't involved in it. So you're right, ARN, and I don't mean this in a disparaging way or a critical way, but they are speaking with forked tongue in a way on this. It is a bit of a high wire act. And so, on the one hand, downplaying the safety issue when it comes to defending Jackie's matter. On the other hand, talking it up when dealing with Kyle's matter. So it can be a little difficult to reconcile. Having said that...
Which is why the cases really do need to go together.
Kyle's case and Jackie's case have been run on very different lines legally. So it's quite possible that ARN could win both or lose both. It's not a mutually exclusive thing here. But I do agree that it takes some work to reconcile the different approaches they adopt in Kyle's case and Jackie's case.
Well, the judge really, there
Pardon me,
goes those
Rob.
lights again.
There goes the light again. I do apologise.
That's all right. The judge did say the reason he was keen for these cases to be together is because he doesn't want different judgments on the same issues, because he said that would take away the confidence in the court.
That is precisely right. That is something that is very much occupying this judge's mind, and that's why it seems almost certain they're going to be heard together in some way. But what he does not want, two separate cases heard at different times with different findings of fact, because that's not something that is consistent with the integrity of the court and the administration of justice. If you have a factual scenario under consideration, there should be the same conclusion being reached. There shouldn't be different conclusions being reached in different matters about the same underlying factual scenario, or evidentiary scenario. So that's of real concern to the judge, and I think that's what's leading him to very much favour the matters being heard together, even though legally there are some substantial differences between the nature of the causes of action being pursued by both Kyle and Jackie. They're very different cases in the way that they're legally structured.
We saw on the weekend that Hamish McLennan, the chair of ARN, and Kyle got together. Would both sides be wanting a settlement at this stage?
Well, I'm sure both sides would want a settlement, as in Kyle and ARN. I'm sure they want a settlement. It becomes a question of on what terms.
Yeah.
I mean, I'm sure if you said to Kyle, we'll settle this matter, you can come back on air on Monday and serve out the remainder of your contract at your $10 million a year, he would love that settlement. If ARN could settle the matter by, say, paying Kyle a couple of $1 million and he goes on his way, I'm sure they would find favour with that settlement as well. It's a question, though, of achieving a settlement on terms that are acceptable to both parties, which might seem like a trite observation, but in this case, I think that's a real problem because of the amounts of money involved here. So one way of ARN avoiding a big hit financially is to say to Kyle, come back on air. But presumably Kyle would want, 100 cents in the dollar or close to it to return to air. He wants to return to air, but he doesn't want to return to air for $100,000 a year. He wants presumably to be very well paid for that. And presumably his starting point would be, well, I want my $10 million a year under my contract. So yes, I'm sure both sides are desirous of a settlement. And it's a case that is crying out for a settlement or a resolution because there's great uncertainty for ARN, which is surely affecting share price and the perception of the company. It's like this sort of Damocles hanging over the company. You've got Kyle, who's not occupied. He's got an uncertain future. Again, it would give him certainty. But the problem is the amounts of money involved. Just nutting out a settlement that's suitable to both parties, I'm sure is easier said than done. So I'm sure they both want a settlement. Achieving it is the challenge.
What happens next? Will more documents come, or will things go quiet until we get closer to the court case in October?
No, a lot more to happen, Rob. A lot more to happen. So evidence is due on 29 May from the applicants. So we'll get affidavits from Kyle. We'll get affidavit from Jackie. Presumably we'll get affidavits too from Bruno and Gemma. And we'll find out a lot more about the factual matrix of this case. So we'll learn a lot more about the ins and outs of what happened on that day and on other dates. So
we're doing a live episode on the 29th of May, Michael.
Well, we may well be. I'll be in Venice on the 29th of May.
Oh, no. You'll have to phone in. You'll have to... They've got internet there. We can do it from anywhere in the world.
We'll work that out. We'll work that out. But I'm living up to the lawyer stereotype. I'll be in Europe in late May. Don't look at me like that. And then there'll be a case management hearing on the 5th of June. On the 5th of June, there'll be another case management hearing.
Does your European sojourn finish by then, or are you still going?
I'll be in London on the 5th of June, Rob. So I'll try and talk to you. You might be lining up a replacement after this. Try and talk to you on the 5th of June. But that'll be interesting. Like the last case management hearing was interesting. We'll get then confirmation. I think the hearing date's pretty much now locked in, whether the case is going to be heard together or separately, consecutively or concurrently, when the evidence for the respondents will be due, and documents and the like. So there's a lot more to come yet. There's a lot more and there might be also some interlocutory skirmishes as well over certain issues, which may or may not be of interest. Often they're just of technical legal interest, but there might be something that emerges that is of interest either factually about what has occurred or in the conduct and course of the case. We might also get a hint, perhaps by 5 June, as to whether there are any settlement discussions or whether the matter has been or will be subject to a mediation. And it's very common for matters of this kind, almost all matters really, at some stage to be mediated. Usually before
But that doesn't affect the trial date, right?
No, it doesn't. No, it doesn't. And it's usually done before a retired judge or an eminent senior counsel. Not always, but that's usually who conducts a mediation of this magnitude to see whether a resolution can be reached. So that's a possibility as well. We might get a hint of that on the 5th of June. We might not as well, because fundamentally mediations are conducted on or without prejudice basis, so the details of the mediation aren't disclosed to court. The fact of it might be, but what occurs in the mediation won't be, and they're conducted on a private and confidential basis. But who knows? Maybe that discussion with Hamish was the seeds of settlement being sown by the two of them when Kyle and Hamish met a couple of last weekend.
Well, I do remember Kyle saying that when there was some big controversy and everyone was in the boardroom talking and trying to work it out, he literally took Hamish out and the two worked out how they were going to handle it and get through it. So they obviously have a good relationship.
And some settlements are reached like that, Rob, where it's just the protagonists meeting and thrashing out a resolution, person to person, man to man. I've had a number of my matters settled like that, where there's been the clients on both sides meeting and agreeing a resolution and telling the lawyers what it is. So that happens. Or sometimes the way these matters sometimes settle, Rob, is someone who is close to both Hamish and Kyle, an honest broker, someone very senior, eminent in business, maybe eminent in the media, comes along and says to Kyle and says to Hamish, this is hypothesizing, by the way, I don't have any insight of this, I'm speaking generally, but this has happened in the past, this sort of thing, comes along and says to both of them, you both need to settle this. Let me see if I can work with you both to try and resolve it. What is it?
Well,
Kyle,
I would do it, Michael, but I think that they would be more likely to go Kyle and Hamish one-on-one. If there's a settlement, that's how it will happen.
But sometimes, indeed, and that's a way they resolve. Other times there's this notion of a very eminent, honest broker, someone who's very, very senior in the media who might be able to broker some agreement. You're willing to offer your services there,
For a small
Rob.
fee.
The Henry Kissinger of media disputes.
Absolutely. I've caused most of them, so I might as well fix some of them too. All right, Michael, that brings us to the end of this edition of Media McKnight. Michael, thank you so much for taking us through it all. I'm sure we will get you on. We just have to convince him while he's in Venice to move away from let the family go out and go on the punts, and he stays in the hotel
I'll be
room.
available, Rob. Don't worry. I'll do my best to be available. Always great fun appearing on your program. Appreciate the opportunity.
Thank you, Michael. Appreciate it. Well, that does bring us to the end of this special edition of Media McKnight. We'll be back as normal next Tuesday at 8 p.m. Australian Eastern Standard Time at youtube.com/@McKnight Tonight. It won't be as long as this one, but it'll be a good one. I'm Rob McKnight. I hope to see you then.